Good morning, everyone, and welcome to this ASATA Live webinar. My name is Natalia, and I'm going to be moderating this webinar on competition law with expert Marilla Govender from Compliance Online. Before we begin, I'd like to hand over to Otto de Vries, CEO of ASATA, who will do a very brief introduction. Over to you, Otto.
Thanks, Nats. Good morning, everybody, from another fresh Johannesburg day. I got into the car and indicated 3 degrees this morning, so I think we can safely assume that we are now in the heart of winter. Thank you so much for taking the time to join us today on what we believe is a very critical component in terms of where the travel industry is evolving and moving towards. And we hope that today's learnings will be of value to all of you in your businesses moving forward. We're very pleased to have with us today Marilla Govender from Compliance Online, and it is my pleasure to introduce you to her and to give you a little bit of information about her. So Marilla's experience in the field of competition law expands beyond 16 years and is currently an executive director of Compliance Online. She holds an MCom in Economics cum laude and an MA in Economics. She has worked at the South African Competitions Commissioner and at Arthur Andersen before spending time as an independent economic consultant on the Competition Law Department of Weber Wenzel's Attorneys and also at Norton's Incorporated Attorneys. Since 2001, she's been involved in the economic analysis of a large number of high-profile cases across a wide range of industries before the competition authorities, and she regularly lectures and conducts workshops just like we are doing today on competition law. She is also the co-writer of the Competition Law Book, a practical guide to South African competition law, which was published in 2017. She is probably one of the most efficient persons that we've ever had the pleasure of working with, particularly on this matter around the competition law. And so we are very grateful to have her knowledge and expertise and have that opportunity to convey that information and knowledge onto all of you. So Nats, I'm going to hand back to you and then we can get started.
Great, thank you, Otto. You will, of course, have an opportunity to ask questions throughout the session, which we'll endeavor to respond either after Marilla's presentation or in between sections of the presentation, if your questions become particularly pressing. For those of you who have never used this particular webinar software before, asking a question is as easy as going to the bottom of your screen and clicking on the Q&A button. Type your question and it will come straight through to me. I'll then pose those questions through to Marilla. There is a chat function at all. You can use the chat function. We prefer it, however, if you use the Q&A folder at the bottom of your screen. If we're not able to get through all of the questions, we will ask Marilla to follow up at a later stage so we can ensure all your questions are responded to. So with that, I'll hand over to Marilla now to take you through her presentation. It's over to you, Marilla.
Thanks. Thank you, Natalia. Thanks, Otto, for that introduction. Welcome, everyone, to this competition law webinar. I'm happy to be your presenter today. So let's proceed. Let's begin. Basically, I think it's important that we understand sort of the background, why we're doing this webinar. And I want to highlight to you some of the key risk areas within the context of your business from a competition law perspective. So the objective of our session today is just to basically provide you with an overview, a quick overview of competition law, and also to raise your awareness about what your potential risks may be. What happens if you don't comply? What are the consequences for non-compliant? And I think it's important from an ASATA perspective to understand that this is part of ASATA's ongoing project to sensitize its members to competition law issues and to make sure that obviously, the competition, we all have to conduct our business within the confines of regulation. And the competition law is one of those pieces of regulation. All right. So we're going to, from an ASATA perspective, one needs to understand and be familiar with what the fundamental principles of competition law are, to be able to identify when potential competition law issues may arise. And the point of this session is not to make you necessarily an expert, but to raise your awareness. And as I said earlier, to sensitize you to these issues and then to understand what happens if you don't comply. And then I think, like any piece of legislation, one needs to have some commitment to complying as well. All right. So why is this timely? I think you being in the industry, know that the industry's probably gone through quite a bit over the last couple of years, driven primarily by technological change. Your industry is not unique in that respect, but perhaps you may feel it uniquely. There's been a disruption of your existing business model. There's been a change into the way you've done business, particularly in terms of how technology has perhaps enhanced that and sometimes maybe made it more complex. And as a result, there's been perhaps a collapsing of the supply chain. And when I say collapsing, I mean there's not this perfect delineation of who the participants are and where or what your role should be. And one may see an encroachment of certain participants in what your particular role would be and so forth. But let me say that's probably all about competition as well. So there is a debate, and I'm not going to go into too much detail on this, about whether technology is enhanced or made it more difficult to compete. It's an interesting one. But certainly, at the nub of it, there have been a number of competition law implications that certainly impact your industry specifically. So from an industry association perspective, I think it's important to understand that, there have been a number of cases that have come before the competition authorities. It's almost 20 or more than 20 years since the Act has been around. Industry associations have actually been caught up in certain anti-competitive behavior. And in fact, some of the very significant investigations have actually started at industry association level and then filtered down to the companies of the individual members of an association. So, the risks for industry associations are basically twofold in some respects. I mean, the one is that an association itself could find it inadvertently or, otherwise, part of an anti-competitive act. But also association members may become parties to anti-competitive agreements. Now, I'm going to unpack a lot of this to you because I'm using these words anti-competitive and agreement. So the question may be, well, what is anti-competitive? And I think that's what I'm here to actually, unpack and discuss with you. What do I mean by anti-competitive, and what do you need to be careful of in a sense? All right. So, So let's understand why. Let's understand why it is that this could happen within the context of the Competition Act. So what are the basic principles of the Competition Act? The Competition Act, broadly speaking, regulates 4 types of conduct. The first one is conduct between what we call firms in a horizontal relationship. Firms that are competitors of one another. That's what we mean by horizontal, right? Firms that are typically at the same level of the supply chain, or are firms that are supplying similar or the same goods and services as one another. Okay, and it's important to understand that. The next one is firms that are in a vertical relationship. In other words, firms that are in customer or supplier relationships. The Act also regulates that. And then firms that are dominant. So if you have an over 45% market share, you're presumptively dominant, and the Act basically is looking at how you should behave when you are dominant. I mean, let me pause there very quickly. We're not going to spend a hell of a lot of time on that. But let me just say, because I often get this question, is that the Competition Act is not saying that you cannot be dominant, right? It's actually saying that if you have a market share of over 45%, then you have special obligations on how you should behave. So obviously most firms want to increase their market share year on year, and you want to be dominant. But the Act is saying, well, if you are dominant, then you have special obligations. And then the last one, mergers and acquisitions. But that crops up as and when it arises, and there's special regulations there. But really, this session's going to focus on the first one. And the reason is because that's basically the most risky type of conduct that exists today globally. The Competition Act basically says that this is the worst thing that you can do, is behave in a cartel-like manner. Excuse me. So basically, what are your risks from a compliance perspective? Because the issue is, well, what are the costs of non-compliance? And let me highlight that to you. Basically, the cost of non-compliance, in a very basic sense, is that there'll be a fine. Right, and that is punishable in terms of certain offenses like price fixing, market sharing, and collusive tendering. And that is what I'm going to be unpacking for the most part of the session. And then there's stuff like minimum resale price maintenance, which I don't think typically applies to you, and then abusive dominance, which I highlighted as well. The other aspect, which has been relatively new, is this whole issue of personal or criminal liability, which I'm going to discuss a little bit. And then, of course, it stands to reason, the competition authorities like to make a big deal if someone is found to have flouted the law, being a cartel or cartelist or colluded. I mean, we all know this, right, from the bread price case, the construction cases. There's been a whole host of cases. I mean, just the other day, I saw there were two matters before the authority where firms in the building products industry had colluded. So, the authorities love making a big deal about the fact that they're doing their job. So there's obviously reputational damage, and if you have shareholders damage to all of that, apart from just the pecuniary implications. Just for a moment, I want to pause at this whole area of criminalization, because this was introduced 2 years ago and was introduced to bring our act in line with what happens globally, particularly in the USA. Where if you have been found to have behaved in a cartel matter, it's not just now the company that's being fined, it's now individuals or directors of that company who can be fined 500,000 or go to jail for up to 10 years. So the reason they've introduced this is there was a thinking, well, the company, kind of pays the fine and people go on their merry way. Still continuing with this type of behavior, there needs to be individual sanction. And so this is why the whole issue of criminalization was introduced. And one of the reasons it was introduced, as I mentioned, was this thing about making directors now personally responsible for the behavior within a company. And it's not just sufficient to say, well, I didn't know, or turn a blind eye to such behavior. And this is not unusual. As I said, in the US, the FBI gets involved. In South Africa, it'll be the National Prosecution Authority. Once there is a finding of cartel behavior, these cases will be handed over to that. So as I say, the equivalent agency in the US is the FBI, and there have been a number of people in jail for this. Look, in South Africa, just to tell you, it's a relatively new amendment. So we haven't had any real sort of actions yet. But it's certainly up the ante, so to speak. So let's get into this then. So what does the Competition Act say about competitor interaction? I mean, this really, as I said, if you have flouted competition, this is really the worst thing you can do. And there are two, what we call species of conduct. Conduct that we call outright prohibited, as you can see there on that slide, I put it in red. Under no circumstances are you allowed to behave in this manner. And what am I talking about? Engage in any form of price fixing, and that's quite a broad term, which I'm going to unpack, what we call market sharing or collusive tendering. Okay, so those are the types of what we call outright prohibited practice. What do we mean by outright? You can't, even if you had a good excuse for behaving in that particular way. Let's say you felt, and I think I've got a scenario here which I will discuss with you, that you got together because your industry was taking a knock, or your company was taking a knock, and basically you're going to be retrenching people. That in itself is not a good excuse. You may think that you're saving jobs, but the fact that you're getting together and discussing this with your competitor is not a good thing. That's what I mean with outright prohibited. So I'm going to unpack this now. I'm going to unpack the whole issue of what I mean by price fixing, market sharing, and collusive tendering. You'll see that I've got kind of an orange block called rule of reason. I will let you know just now what I mean by that. Because there are certain types of conduct which the competition authorities say, well, we recognize that competitors may need to get together. There may be a dampening of competition, and there is a weighing up exercise. But that's by far not the emphasis here. But I will highlight that too. So I'm going to unpack each one of these concepts: price fixing, market sharing, and collusive tendering. Let me just say that, and I highlighted this the other day, is that when we look at the principles of competitive interaction, the one thing you should really remember is that you should behave independently of your competitors. So the Competition Act is drawing a distinction between lawful independent behavior and what we call illegitimate collusive practices. The Act is particularly concerned when competitors or firms get together, because the thinking there is when you get together, you're actually behaving as a monopolist. And the basic economic principles of when you behave like a monopolist is that prices are higher than they would be under competitive circumstances, or service is worse off. All those dimensions of competition, or what one would say on a philosophical level, the fruits of competition are not there if you are colluding, okay, because you are exercising what is called collective market power. So, the question you may ask yourselves, and I think it's very pertinent, and I'm pausing for a moment here to unpack this a little bit, is who are your competitors? Because I said you're not allowed to collude with your competitors. So in some industries, it may be it may be easy for you to identify who they are. Just remember, your competitors are those firms that are actually in the market with you and those firms who could potentially compete with you. Okay, so competitor is anyone who supplies the same good or service to you, to the same customer grouping in the same geographic market, or can easily adapt its business to do so. Right, please remember that. So it may be that you could have these kind of nebulous industry distinctions that say you are X and you are Y. So because you have different names and so forth, you may think, well, they're not really competing with me. But a competitor is someone, if you're supplying the same customer, but you have different levels of the supply chain, you are competitors. Okay, so it's very important to understand that. And when I say you supply the same customer, I mean the same customer with the same good or service. All right, so again, to just emphasize this, the principle of competition law from a competitor interaction perspective is independent decision making. In other words, obviously you can make decisions taking into account what is available publicly in the market, based on internal strategies and so forth, but that is information that you've gleaned from your own knowledge of the industry and so forth, not by interaction with competitors in some sort of anti-competitive way. Right, so what does this mean for an industry association, basically? It means that participating in an industry association, while it's absolutely legitimate, and I know, it's very useful to be part of it. So there's nothing wrong with industry associations at all. And there are many benefits to you as members and ultimately to consumers. It is risky because you get competitors getting together. And when you get competitors getting together, there may be the inclination, purposefully or inadvertently, to engage in certain discussions that overstep those boundaries, and so forth. And that is why there is this particular issue. The other aspect I want to highlight here is that I said is not, you're not permitted to agree with your competitor. So some individuals take an agreement literally in the legal sense. Very few anti-competitive collusive acts happen through any formal agreement. The vast majority of them happen through informal discussions. Meeting up at a coffee shop, on the golf course, at a social event, at a trade show, where you're just discussing something informally, and this sort of thing snowballs. So it's very important to understand this, that often these sorts of things take place through casual conversation, and very rarely in a formal sense. It could take place through a text message, an email, and so forth, but that's about it. Often when we talk about written, or when we talk about agreements as a concept. So it's not necessarily a kind of a written or formalized thing that's down on paper. Something else to understand is, in fact, the mere fact that you spoke to a competitor about issues pertaining to kind of confidential company issues, and you shared this with them, is problematic. The fact that your competitor could have walked away and not acted on this information is in fact of no consequence. I mean, I've seen arguments to this effect, but it doesn't actually hold. So it doesn't have to be implemented. The mere fact that you got together with your competitor and discussed these issues doesn't even actually have to have caused any harm. And it is on any issue pertaining to price or terms of supply or trading terms. So it's important to remember this. So what is this first concept that I highlighted to you of price fixing? So price fixing is where there's some agreement among competitors to raise prices, lower prices, stabilize prices, discuss any element of prices related to volumes, conditions of supply, and so forth. So let me give you an example of real life price fixing scenarios. I mean, we all know the bread price issue, right? There, it was where a wholesaler basically got hold of a letter from all these manufacturers, being Tiger Brands, Pioneer Foods, Premier Foods, that pertained to the discounts that they discussed. And he got these letters, and they all spoke about price increases that were of basically the same nature and at the same time. And he became suspicious of this. And that opened this whole investigation.